All right. In the interest of time, we will go ahead and get started. Good evening, friends. Welcome to our third of 4 seminars with Professor Carter Snead on what it means to be human. I'm Kristen Collier. Thanks for joining us tonight. On behalf of the University of Michigan Medical School program on health, spirituality, and religion, we are thrilled to co-host this series with the Bur Oak Foundation. Before we get started, just a reminder that Carter will give some opening remarks for the first half or so of our time together, as we've done before. And then we will spend the remainder of our time together in discussion and Q&A. We, as we did last time, will be utilizing the Q&A function to take your questions. Please send your questions at any time during Carter's remarks as they come to you in the Q&A, and then we'll get to them at the end. We are recording the session and we'll make the video available as we have the other sessions once it's posted on the Bur Oak website. So tonight, we are going to be discussing anthropology and technology. And as per our other seminars, we will engage challenging, difficult topics and questions. I applaud all of you for being willing and able to engage in this space tonight. Our goal is to engage one another in this challenging space of ethics and respectfully interact, given I know the various viewpoints that we all hold on these matters. I formally introduced Professor Snead at our first session, and I'm really thrilled that he's come back to join us again tonight. And I'm now going to have Dr. Bufiel from the Bur Oak Foundation open the session with some opening remarks that hopefully will be thought-provoking to get us started. Joe?
Thanks, Kristen. The practice of assisted reproductive technologies, or ART, defined by the CDC as a subset of fertility treatments that involve handling embryos or eggs in a lab, brings with it important and at times unforeseen ethical considerations that are the subject of tonight's presentation by Professor Snead. For starters, we could ask, should we accept and promote any technology that science offers without first carefully considering the consequences? In the case of art, this question has been answered with a resounding yes. In the case of art, the science has moved faster than the ethics. Consider the cautionary words of 4 prominent reproductive endocrinologists, stem cell biologists, and bioethicists published in January of this year in the Journal of Assisted Reproduction and Genetics. And the passage I'll read from this article is adapted for the sake of time to the purposes of our discussion. So the authors write, "The treatment of infertility has become big business around the world. A medical specialty that began as an academic, innovative research activity has now evolved into an industrial and commercial service that has expanded well beyond the treatment of infertility. Treatment options originally aimed at infertile couples are now aggressively marketed to a broader population of young, fertile individuals. This marketing includes many promises, a long list of medical interventions referred to as add-ons have been introduced over the past decade. Surprisingly, many such interventions have, however, yet to be clinically validated. As a result, the practice revenues have been enhanced while patient costs have escalated. How did we get here, and where is the field going? Why are increasing amounts of private investment dollars flowing into the IVF world? Is a rapid increase in treatment demands, as witnessed over recent years for fertile individuals, an ethical practice of reproductive medicine? Now, these authors are professionals who either in practice or in theory favor art. Their concerns are related primarily to the fact that financial interests seem to have trampled scientific rigor. Other ethical concerns about art have been advanced, grounded primarily on the moral status of the human embryo. Some intellectual traditions, most reliably the Catholic tradition, argue that every human being has an inherent special status and unique role to play in the cosmos. And so the life of each human being, without exception, should be cherished and protected from the moment of conception to the moment of natural death. This basic statement, grounded on both rational argumentation as well as on claims of divinely revealed truths, preceded by centuries the lights offered by modern science today. So it would be appropriate to confront the two sources. Does science today support or refute the religious claims of human exceptionalism? In the normal process of human reproduction, the egg floating passively in the fallopian tube is penetrated by a single sperm that has actively migrated up the uterine cavity. That merging of gametes brings together two half doses, maternal and paternal, of a complete genome. And because of the genetic reshuffling that occurs during the formation of sperm and egg during meiosis, the new genome generated by that merging is statistically, mathematically, unique and unrepeatable. In other words, the specific genetic sequences brought together at conception that determine individual variations and distinctions apparent across our species have never occurred and will never occur again. The mold for that particular human individual is broken at an N of 1. Statistically, the probability of there being two genetically identical human beings is asymptotically as close to 0 as possible. So every conceptus is a unique and unrepeatable individual member of the human species. This is so, according to science, not only because of the variations of the sequence of base pairs in the DNA, but also by virtue of the epigenetic events that occur at conception. The first major biological event following the merging of maternal and paternal half genomes is a generalized demethylation of the maternal and paternal genomes. This event leads to erasure of imprinting patterns of parental genomes and the adoption of the distinctive imprinting patterns proper to the new biological entity. From that moment on, all the material required for that entity, the zygote, to develop into a fully mature adult human being are present, contained in the small sac called the zona pellucida that sets the new individual apart from its surroundings. All subsequent development is internally directed, driven by the coordinated activation and inactivation of the genetic complement inherited within that new human being. Only food, water, and shelter are needed for that biological entity to grow and develop, elements which in the normal case are provided in utero by the mother. The insights of science, therefore, do not contradict the claims of religion. Every member of the human species is, in fact, exceptional, a unique and unrepeatable entity from the moment of conception. If, from the moment of conception, that entity is biologically human, statistically unique, temporally unrepeatable, and capable of autonomously determining its own physical development, should we not confer the rights of personhood on it? One of the intellectual founders of modernity, Immanuel Kant, famously claimed that it is immoral to use another person merely as a means to an end, and that people must, under all circumstances, be treated as ends in themselves. Shouldn't we pause and reflect when one person or a group of persons decide to pay to manufacture another human being, evaluate it for desirable features, and discard it if deemed unacceptable? Should frozen embryos be used for research? What binds biological parents to their children? What responsibility do gamete donors have toward their progeny? These questions, difficult questions, point to widespread social attitudes of expressive individualism that Professor Snead examines so effectively and comprehensively in his book. And so we are very fortunate to have him with us to help discuss, frame, and sort out these difficult questions. Thank you.
Thanks, Joe. Carter, thanks for being here.
It's my pleasure. Thanks for having me back. It's great to join you all, Kristen and Joe. It's great to be back with you all. As you can see, every time with each successive talk, I'm going to be more casually dressed than I was before. To a point, I'm probably going to wear just a hooded sweatshirt for the last one. And it'll say Notre Dame on it. I don't want to trigger the people of Michigan, but it's going to be, I have to do it. In any event, that's a great introduction, Joe. Thank you so much for taking us through such complex ideas in such a straightforward way. My talk, again, for those of you who participated in the previous sessions, what I'm going to do is give a very brief recap of the framework of the argument for the book generally, the argument, the sort of methodological piece and the substantive piece. And then I'm gonna try to run through that fairly quickly since we've talked about that 2 times now. But for the benefit of those who are just tuning in for the first time, I think it's worth recapitulating. Also, it's been a couple of weeks since I've said this, so I might as well say it again. Let me share my screen with you now. This may look familiar. And so, again, for those of you who are joining for the first time, there are essentially 2 claims that I'm making overall in the book, and then as applied to the 3 specific vital conflict subject matter areas that we are going to discuss over the course of this seminar. We talked about abortion last time. We're going to be talking about assisted reproduction this time, and we're going to be talking about end-of-life matters in our final session. But the methodological claim of the book, as Joe alluded to, is an argument about how best to understand, unpack, critique, and just think about different matters of public bioethics. Public bioethics being defined as the governance of science, medicine, and biotechnology in the name of ethical goods. It is the point at which the law and public policy come into contact with the ethical questions that arise from advances in biomedical science and biotechnology. And the argument in the book, as I've discussed the last 2 sessions, is that I think the richest and most potent method of analyzing matters of public bioethics is through what I describe as an inductive anthropological inquiry. And that may seem like a very technical or highfalutin expression, but it really only means something very simple, namely, it's inductive in the sense that you take the law and policy under consideration as you find it. And then you ask the question, what is the vision of human identity and flourishing that anchors and animates the law and policy in that particular domain? That's what I mean by the anthropological question in its sort of original sense, as an account of what it means to be a human being. So that's the method that I apply to what I describe as the vital conflicts of American public bioethics, the legal disputes over abortion, the legal questions and policy questions that concern assisted reproductive technologies. And then, of course, later on, we'll talk about the legal and policy questions that arise from end-of-life decision-making. When you apply this anthropological inquiry to these three areas, what I found, what comes to the surface, is the grounding for the substantive claim of the book, which is to say that the dominant anthropology in these particular vital conflicts, and probably other areas as well, is a vision of the person that very closely resembles what Robert Bellah, social scientist, and philosopher Charles Taylor, and many others have described as expressive individualism. And I'll say a little bit more very briefly what I mean about that in a moment. But the most important takeaway, though, is that this vision of expressive individualism as an account of what it means to be and flourish as a human being is inadequate as a grounding for laws and policies that are under consideration in the book, because this vision of personhood, expressive individualism, fails to take into account the essential lived reality of our human embodiment. It fails to take on board or even to be able to render intelligible the fact that we are bodies, that we live as bodies, we experience ourselves as bodies, one another, the world around us as bodies, not in bodies, but rather as bodies. Our embodiment, I argue, is integral and an inexorable feature of what it means to be a human being. And by virtue of the fact that we're embodied beings in time, we're not mere bodies, by the way, we're with a dynamic union of mind and body. And so there's something true about expressive individualism, but it falls far short of the whole truth. And that's why it ends up being an inadequate normative grounding for an anthropological grounding for the laws and policies in this area. Because it fails to see that our human embodiment as fragile beings in time, subject to illness and injury and aging and other kinds of vulnerabilities, our vulnerability is an inexorable piece of our lived experience. And our vulnerability leads us to be reciprocally dependent upon one another. It actually situates us in a relationship to one another in a very particular sort of way, a relationship of mutual dependence to respond to our vulnerability, to respond to our subjection to natural limits. But these realities of what it means, but they're challenges, they're also gifts. We can talk about that later if you like. But the reality of human embodiment is such an essential part of what we are. Any anthropology that fails to take it into account is going to fail as a grounding for law and public policy. So I've already said what public bioethics is. We don't need to belabor that. It's an area of law and policy that concerns ethical questions relating to biomedical science, biotechnology, the practice of medicine. The anthropological analysis of law, I briefly sketched out. I'll say a couple more words about that. I'm going to say a few brief words about expressive individualism and why I think it's an incomplete conception of the self, that is, to use Alistair McIntyre's phrase, a forgetful of the body. And then I'll talk a little bit, again, briefly, about what we should do to try to augment this incomplete and false anthropology so that we can actually erect laws and policies that are responsive to the human condition, that are responsive to the needs and desires and other aspects of our existence as embodied beings. And that's going to require us to remember the body and to try to think about what embodied beings need to flourish and even to basically just to survive. And then to think about what it takes to construct the kind of background conditions and intentional frameworks that are necessary to promote human flourishing and to ensure our survival. Okay, and then I'm going to talk about assisted reproductive technology. So already talked about public bioethics. Couple of sessions ago, I talked about the birth of American public bioethics as a responsive and reactive form of governance, reactive to scandals. The Beecher article in New England Journal of Medicine in the 1960s, the Tuskegee scandal, the scandal involving research involving newly born, just aborted, imminently dying neonates abroad. We covered that 2 sessions ago. Talked about the congressional hearings that gave rise to the National Research Act, that created the first National Commission on Bioethics. So there's no need to go over that again, but let me say very briefly why it is essential to ask the anthropological question when you're analyzing any area of law and public policy. And it's very simply this. Law is about and for the protection and flourishing of persons. That's a pretty good, simple definition of what the ends of law are. And the only thing that makes law intelligible and the measuring stick by which we can analyze law for its justice, its wisdom, its humanity. So law is about and for the protection and flourishing of persons, and therefore it unavoidably must rest upon usually undeclared conceptions of what a person is, what human identity is. And if as an institution, the law is meant to protect persons and promote their flourishing, it has to have an operational definition of what a person is. And usually those are not articulated in the statutes or the decisional law or the legislative history or even the political discourse itself. It's very rarely the case that we actually grapple with that first order question of what it means to be a human being. But it's essential to do that in order to understand the law's foundations at its deepest level. Because if the law gets the question of what a person is wrong, then its entire apparatus is going to go in the wrong direction. It will not be able to respond to the human beings in their lived reality. It won't be capable of addressing all the needs and wants and avoiding all the harms that human beings encounter in their daily life as embodied beings. So we take the laws, we find it, and we ask who and what does the law assume a person to be? And is the law built on a true or false understanding of human nature? Now, I argue, and as I've said a couple times now, when you ask that question, what comes to the surface is this conception of expressive individualism. And I'll very briefly recapitulate really what that means. Expressive individualism understands the fundamental unit of human reality to be the individual, the isolated, unencumbered, atomized, to use Charles Taylor's word, individual self. That's the fundamental unit of human reality, shorn and abstracted of all attachments, all relationships, all community connections, religious connections, family connections. It shears all of that away, and it treats the individual self as the primary unit of human reality, as I said. But the person is not defined in a comprehensive way. The person is defined as coextensive with and exclusively in relation to his or her will. That is, his or her mind, the cognitive capacity to formulate desires and to pursue desires and to formulate plans to pursue those desires. And everything else other than the mind and the will is sort of accidental and not essential to the identity of the person. You are your mind. You are what's in here, okay? And especially insofar as you are able to interrogate the depths of yourself to identify your authentic truth, your authentic desires, and then to configure your life plan accordingly. You are defined primarily as an individual chooser or consumer, and human flourishing is defined, as I say, as the pursuit of projects of one's own construction. Again, you look inside yourself, you listen to the inner voice, and you find your authentic truth, you find your originality, and that becomes your North Star around which you configure your entire life plan. And it is an imperative to live your originality. You have to be yourself. You have to be the you that is inside yourself, and everything else around you, your body, relationships, the natural world, all of which is instrumental towards the pursuit of your own authentic original truth. It is a vision of human flourishing and human identity that is profoundly anti-teleological. That is, it rejects the notion entirely that external givens observable in terms of my, what my body looks like, what the natural world looks like, what it can do. You cannot infer from external phenomena what the fundamental purposes of things are. There are no ends embedded in natural givens in this worldview. And the only thing that's definitive and determinative of any kind of normative decision making is the unique and original inner voice. There is no discerning or negotiating the physical world and learning the meaning of the physical world by studying the manifestations of the physical world and the objects in it. There are also no unchosen obligations or constitutive attachments. As I say, it's an individualistic kind of vision of human identity and flourishing. The only people that have claims on me and the only claims that I can make on others are those that we have agreed to in advance, that it's in the domain of consent, and therefore relationships are instrumental and transactional. We can come together, our atomized individual wills can come together in pursuit of a mutually beneficial plan, and sometimes that happens, but once that common good or that mutual benefit that we're both aiming at ceases to be interesting to us, then that partnership will simply break apart. More frequently, rather than collaboration, persons encounter each other as isolated adversaries. You have to overbear other atomized wills in this space. So the world of expressive individualism is a world of strife. And ethical goods ultimately are reduced to autonomy, which is the highest good to which all others are subordinated, the freedom to assert the unencumbered self, to find the freedom to find the truth inside yourself and to pursue your dreams. And injustice is conceived as a kind of constraint on freedom to pursue the projects of your own choosing. And then to build out and to think about what the role of the law and government should be, and even social life, our shared life together should be, is simply to remove constraints, public constraints, private constraints, perhaps even natural constraints, and otherwise provide the conditions of the assertion of the unencumbered individual self. Now, as attractive in some fundamental ways this vision might be of the lonely individual, bestriding his environment and bending the world around him to his will, there's something kind of in a base sense sort of very attractive about that, in the way that teenagers and sociopaths are attracted to that kind of worldview. But as attractive as it might be, it is ultimately not adequate, because it's just not true. Lived embodied reality is not the domain of the assertion of the unencumbered will. In the very best case scenario, the picture of human flourishing that is at the core of expressive individualism is a snapshot, a brief snapshot in time of a very narrow sliver, highly privileged segment of the human community at very one short moment in his or her lifespan, right? I mean, we begin our lives in complete and utter dependence upon others, even for our basic survival. If all things go as best as they possibly can, we begin a gentle curve upward towards the height of our powers, after which we begin a decline, which ends again in total dependence, just in the same way that we began life. And again, that's the best case scenario. Frequently, people have disruptions, injuries, illnesses, other kinds of circumstances in which they become dependent upon other people, even in radical ways. Some people are dependent on others for their entire lives. And so that would mean that expressive individualism doesn't give any coherent account or intelligible account of who or what those people are. And this becomes a serious problem when expressive individualism becomes the core of your legal framework. It can't even see, much less respond to, the weak and the vulnerable, the elderly, children, and the disabled. Lived embodied reality, as I said before, is characterized by mutual dependence and vulnerability and natural limits. And therefore, the fundamental need for embodied beings is not the freedom to assert the unencumbered will, but rather what McIntyre calls networks of unconditional and uncalculated giving and graceful receiving. That is, networks of human beings who are willing to make the good of others their own good without seeking anything in return. Everyone who can hear my voice or see the screen right now is here because someone did that for you. So probably your parents. Someone took you in the moment of profound vulnerability when you came into the world, made your good their good, and took care of you. And so you can see in that very narrow example, and parenthood, by the way, is the kind of network of uncalculated giving and graceful receiving par excellence, the parent-child relationship. And that becomes very important for the subject we're about to talk about, assisted reproductive technologies. But we need these networks to survive, obviously, but we also need them, and this is a normative argument that I'm making, to learn to become the thing that we're meant to be, to learn to become the kind of being that can make the good of others our own good without seeking anything in return. In other words, we're most human and we flourish. Our human flourishing is at its apex when we're caring for other people. And those of you who are studying medicine are entering a profession and a vocation in which that is at the core of what your very life's aspiration as a professional. Put a different way, I argue that human beings are, by virtue of their embodiment, made for love and friendship. Our embodiment stands us in a particular kind of relationship to each other and defines our flourishing as love and friendship. And as I said, expressive individualism can't make sense of any of that. It misses the reality of human mutual dependence. It can't recall or foresee the past or future vulnerability. It doesn't recognize claims of unchosen obligations. It can't recall these debts. It can't repay these debts. It's intolerant of imperfection. And the consequences are it's unable to recognize the unchosen claims of the weak, including children, the disabled, and the elderly, as I said a moment ago. It also leads to loneliness, dislocation, and alienation. There are no constitutive relationships. Everything that defines you, is in your head and inside you. Everything else is an instrument. And that's a very lonely world, but it's also a frightening world. And it's death haunted, as Solzhenitsyn says, because when you're the entire focus of the universe, when it's just about you, your life's end is the extinction of the universe, which is a terrifying thing indeed. And then even more close to home, as Taylor and Bella saw this in his social science evidence and the book Habits of the Heart, that expressive individualism leads to the erosion of social and familial ties. It's not surprising. It's kind of acid that dissolves our connections to others. And so what are we supposed to do about this? How can we at least conceptually begin to think of ourselves in a different way? And again, I think the place to start is to think about what it requires to build and sustain these networks of uncalculated giving and graceful receiving. And as McIntyre says, to build these networks, there are certain kinds of virtues and practices that are essential. And he lists some virtues and practices in his book, Dependent Rational Animals. I took that list and then expanded it a little bit, but ultimately they are the virtues of uncalculated giving and graceful receiving. The virtues of uncalculated giving are the virtue of just generosity, giving in proportion to a person's need. The needs of the other define what you give and how you give. It defines what's just to give to those. Hospitality, welcoming the other because he or she is a stranger, because they are other, not because you're hoping to get something in return. And misericordia, which is a very important virtue for doctors. That is to make the suffering of the other your own suffering, and seek to heal or to comfort, and when that's not possible, simply to accompany the other in his or her suffering. And then the other side of the virtues of acknowledged dependence are graceful receiving, chief among them the virtue of gratitude, practicing gratitude, recognizing, exercising your moral imagination to remember your vulnerability and to see into the future and the future vulnerability that you are heading toward, that we're all inexorably heading towards, and realizing that we're here because somebody took care of us. We didn't invent ourselves. We didn't create ourselves. We are this part of the sustained efforts of others, people who loved us, people who took care of us, people who made our good their good. And when you realize that, that should engender a feeling, an emotion, a sentiment of gratitude, which also engenders a notion of humility, the idea that everything is a gift. Everything is gift. And so because I've been gifted such a wonderful life as I have it, even in the most difficult of times, that should make me alive to the needs of others, and it should make me alive to the proposition that gifts are distributed unevenly, and those who don't receive gifts to the same extent that we have an obligation to them to try to care for them and to do right by those folks. This gratitude and humility also should lead one to be open to the unbidden. It should be a kind of antidote to the push for rational mastery and control and extractive attitude towards the world around us, and perhaps even other people around us, that is at the core of expressive individualism. Openness to the unbidden and tolerance of imperfection. These become very important concepts, again, as we make things more concrete in a moment, talking about assisted reproduction. The good of solidarity, the idea that we all are in our mutual vulnerability, are all connected to each other and stand in relation of giving and receiving, should engender a sense of respect for the equal dignity of all human beings, for the need for truthfulness. But all of these virtues of acknowledged dependence, it seems to me, can be framed and understood through the lens of authentic friendship, making the good of another your own good. And so through the practice of these virtues, we shore up the networks of uncalculated giving and graceful receiving, and that becomes the metric for our success or failure as a community, as a civilization. How well are we taking care of one another, including especially the weakest among us? So let's now pivot and make this a little bit more concrete. Okay, now that we've recapped the previous discussion. remember, what we're doing here is we're doing inductive anthropological analysis. We're asking, what is the vision of the human person and human flourishing that anchors American law and policy concerning assisted reproduction? Okay. And let me just I'll remind you everyone of this in a moment, but it's really important for me to say at the outset, when I describe the anthropological premises of this legal landscape as expressive individualism, I'm talking about the premises on which the law rests. I'm not talking about the attitudes or views of the people involved in this human context. I'm not talking about the attitudes of physicians. I'm certainly not talking about the attitudes of patients and people who are seeking to become parents. I'm not talking, in fact, and as I'll underscore in a little bit, the main point here is that the vision of the person in human flourishing, what human beings need, that the law assumes is profoundly asymmetrical and different and departs from what actual patients want and need. And it's that disconnect that causes the serious problem that we see in the legal landscape of assisted reproduction. So I just wanted to preface all of this by saying and reminding myself and you listeners that I'm not, when I talk about expressive individualism, I talk about this vision of human flourishing, I'm not talking about the attitudes of people. I'm talking about the premises of the law. I'm talking about the law's suppositions about what people want and need. Okay. So let's take the law very briefly of assisted reproduction. What is the law of assisted reproductive technologies in America? Well, it's very easy to describe. Its primary feature is the absence of law. Unlike the context of abortion, where we discussed last session, where the entire legal field is occupied by the Supreme Court. The Supreme Court defines what the law of abortion is in America. Private ordering is the principal mechanism of human arrangements, governing human arrangements in the context of assisted reproduction. It's basically a space where there's not very much law. Assisted reproduction is regulated legally as part of the practice of medicine. And the practice of medicine, as you all, I'm sure, know already, is regulated primarily through licensure and certification at the front end of the practitioner's process. Okay, so doctors are licensed and certified at the state level, and once a doctor is licensed and certified by the state in which he or she practices, the ongoing regulatory mechanism for American medicine is primarily malpractice litigation. It is lawsuits. It is lawsuits brought by patients who believe they've been injured by doctors or other healthcare providers who have failed to observe the standard of care, which is a legal standard. It's a legal common law standard in the American law of torts and the special subspecialty of medical malpractice. That's the principal mechanism of government regulation of the practice of medicine once physicians are licensed and certified. Now, we do have, of course, the work of disciplinary boards and so on for misbehavior and misconduct on the part of doctors. But that's a pretty narrow area, and is not the same. It's not the same thing. It's not the same legal regulatory apparatus that we're used to for other fields of human activity. Now, it's a good thing, I think, that doctors have wide-ranging freedom to practice medicine according to their training, according to their judgment and their creativity and their dynamism. It makes sense that the practice of medicine is from a governmental perspective fairly unregulated in a sort of the day-to-day sense. The judgments of doctors are not overseen by any government agency or anything like that. Food, Drug, and Cosmetic Act does not regulate the practice of medicine. The FDA doesn't regulate the practice of medicine. It regulates the manufacture and labeling of products that are used in the practice of medicine, but the FDA does not regulate the practice of medicine itself. That's something that is achieved through these other mechanisms that I've mentioned. Okay. Now, in most cases, as I say, it's a good thing that doctors are not regulated very aggressively and very comprehensively in an ongoing way. However, one might ask, and people have asked, and I think it's reasonable to ask, does that make sense as a regulatory framework when the treatment, in fact, involves the creation of a new human being? That is, that we're talking about IVF or reproductive endocrinology, when the end point of the medical intervention is the creation of a new distinct human being. And we don't even have to get into the weeds on the moral status of the embryo or the fetus. The goal of this process is a live born child. Okay. And that's a successful result in these interventions in terms of the case of infertility. Okay. So, but nevertheless, this is a highly unregulated area of human activity, such that techniques that are developed very quickly, IVF, these adjunct techniques that Joe alluded to, in intracytoplasmic sperm injection, pre-implantation genetic diagnosis, different kinds of zona pellucida manipulation, all of that moves from the bench to the bedside almost instantaneously. And in fact, many of these practices were done in human beings before they were done in animal models, which is also interesting and controversial, obviously. So the practice of medicine is the principal regulatory mechanism, which translates to not much day-to-day oversight by a governmental agency or governmental body in the practice of ART. There is a federal statute called the Fertility Clinic Success Rate and Certification Act of 1992, which is a very weak consumer protection public information law. It simply solicits certain kinds of information, not really even that comprehensive, that the CDC then publishes in a kind of report online, which lists primarily success rates, some other data that's of interest to consumers, although some data that's not, that would be of a lot of interest, adverse results, for example. They're not very readily transparent in this reporting and publication process. In fact, there are some patients' rights groups. The American Fertility Association, for example, has complained that this is not, it's not intelligible to a lay patient how to understand what these numbers mean. And the only penalty for not reporting your information to the CDC is that you get listed as non-compliant, and but that's it. And you're listed as non-compliant in a report that almost no one sees. And if you look at the non-compliant list, you see the names of a lot of very prominent IVF clinics in the country. So there's also sort of a subspecialty of law involving custody disputes over IVF embryos, usually in the context of a divorce proceeding. Again, that's a very niche thing. It doesn't constitute an ongoing regulatory apparatus. And then, so what it means then is that in the absence of day-to-day regulation and oversight, you have what fills that gap is professional self-regulation. And the American Society for Reproductive Medicine is the principal professional society that regulates and promulgates professional guidelines, promulgates ethical guidelines, and so on. Okay, so taking a step back once more at the 30,000-foot level of abstraction, the primary feature of American assisted reproduction is the absence of law. It's been described as the sort of Wild West. Now, what would the theoretical underpinnings of this lawless landscape be? How should we understand what the purpose and function of this kind of wide open space is, this space without guardrails? And for that, it's useful to look at the writings of Professor John Robertson, the late Professor John Robertson, who passed away a few years ago. He was a law professor at the University of Texas and the former chair of the ASRM Ethics Committee. He was on many bioethics committees, important federal level bioethics committees over the course of his illustrious career. He's very, very prominent philosopher and legal scholar. And as a central player for ASRM and in the construction of its ethical apparatus over the years, and his authoring and overseeing different ethical guidelines and even practice guidelines, it's useful to see what John Robertson thinks the purpose or why there's a fundamental right, why it is assisted reproductive technology is so valuable. What is ART for, and why is it important that people have the freedom to choose ART unmolested by a regulatory apparatus that oversees them on a day-to-day basis? And if you read his book, 1994 book, Children of Choice, John Robertson couldn't be clearer. He says, the choice to pursue or avoid procreation is essential to self-definition, the pursuit of desires, and self-expression. That's his account of what's important about the freedom, about reproductive freedom, about the freedom of assisted procreation, okay? It's because procreation is essential to self-definition, the pursuit of desires, and self-expression. Now, when I was general counsel to President Bush's Council on Bioethics from 2002 to 2005, we took up this question of assisted reproductive technologies. It culminated in a report in 2004 called Reproduction and Responsibility, the Regulation of New Biotechnologies. And as part of our fact-finding prior to that report, we invited some very prominent practitioners of IVF and related practices to come speak and give testimony to the council about various matters. We invited Dr. Jerry Shatton, who was then at the University of Pittsburgh, who was heavily involved in research involving ART, especially genetic screening. And we asked him, we gave him 6 weeks head start to think about the question, what is the goal of genetic screening and assisted reproduction, which is ubiquitous. As Joe said, genetic screening is a very, very common adjunct technique that is associated with ART. You pay extra for pre-implantation genetic diagnosis, or you can get chromosomal analysis. And we'll talk in a minute about what the most prominent services are, what the most prominent tests are for. Jerry Shatton said the goal of genetic screening and assisted reproduction is to quote, to help parents realize their dream of a disease-free legacy. Now, if you look at these two statements and you put them together, the choice, the fundamental value of the freedom of reproductive liberty to pursue or avoid procreation is essential to self-definition and pursuit of desires and self-expression. And then you pivot and you think about, well, okay, what about genetic screening in this context to help parents realize their dream of a disease-free legacy? What starts to come into focus looks an awful lot like, or points in the direction of expressive individualism. It looks like if you wanted to construct a landscape, a legal landscape in which expressive individualism was your core animating anthropology, and these two normative statements were at the heart of what you were trying to accomplish, what the resulting framework would look like would be an awful lot like what we have right now in the United States. It would look like a framework of essentially unfettered choice, the freedom to make a baby by almost any means that a doctor is willing to do. It's consistent with the standard of care, and without limits, right? And so, and again, I'm not suggesting, and please don't hear me suggest that this is the view of how parents understand what they're doing when they seek fertility care. That's not at all what I'm saying. In fact, I'm saying quite the opposite. I'm saying that this vision of what a patient needs and wants is not what a patient needs and wants, or even understand themselves to need or want. And yet this is the normative grounding and the normative explanation that renders intelligible our legal landscape for assisted reproductive technologies. And the consequences of that landscape are quite significant. Obviously, we see in the United States, the practice of IVF has resulted in a high incidence of multiple gestations, which cause health risks, certainly for children associated with prematurity, and also for the women who bear those children. We are, it seems, getting better at single embryo transfer. That's becoming more and more common. And so I think the rates of multiples are not what they were, say, in the early 2000s, but they still are quite significant. They are orders of magnitude greater than the incidence of multiple gestations and births in unassisted pregnancies and unassisted conception. We now have studies suggest 1 million embryonic human beings frozen in cryostorage in the United States. We have widespread practice of genetic screening. That image you see there with the pipette is it's biopsying certain kinds of a certain number of blastomeres to analyze the genetic constitution of that embryo, removing a significant percentage of the overall cell mass. We still, by the way, don't have longitudinal studies of the long-term health effects on children, women, children conceived by IVF, children conceived following PGD or intracytoplasmic sperm injection, or what have you. We just simply don't know. One of the recommendations of the President's Council on Bioethics was for the federal government to fund a longitudinal study. And by the way, that recommendation was something that one of the major patients' rights groups, which was generally suspicious of the work of the President's Council on Bioethics, was very enthusiastic and supportive of. Sex selection is a common practice in American IVF. And let me read you something from my book. The 84% of clinics offered pre-implantation genetic diagnosis for family balancing, and 75% of clinics offered it for purely elective sex selection for patients not suffering from infertility. Okay, so that means, so not all clinics, 94 of all clinics in America, 94% offer sex selection for family balancing, which is to say choosing the sex of one's offspring in light of current family composition. And 81% offered it regardless of the patient's rationale. And as I said, a very substantial, significant, overwhelming percentage offered it to parents who were not infertile for any reason at all. Trait selection. There are industries, there are people out there who are charging money to do to try to analyze using PGD the genetic profile of embryos and selecting for those embryos and discarding those that don't meet the standard, the pre-established standard for eye color, hair color, skin color. They're aggregating genetic information to try to make predictive judgments, give probability scores for low IQ. The same scientists are suggesting in a manner of years, when they get enough data, will be able to do the same thing to protect high IQ. You can only imagine what the market will be for these kinds of interventions. And then, of course, with access to embryos and to ova and the research that engenders, that creates a sort of market for other kinds of embryo research, including research into human cloning. There are markets for gametes. Young women, I'm sure at the University of Michigan, receive in their mailboxes solicitations to sell their eggs, in some cases for tens of thousands of dollars, depending on their health, medical history, their SAT scores, their height, and their appearance. Sperm also is an object of commerce. It's less costly to obtain, less dangerous to obtain. And of course, we see consumerism even entering the context of gestation and childbearing itself. We have, in this image, you see a family who contracted with the woman you see holding the child to carry their baby as a gestational surrogate. When they found out the baby had Down syndrome, they demanded the woman get an abortion. Despite the enormous pressure on the woman, the sort of social and emotional pressure on the woman, she stood firm and said no, she wasn't going to do it. Now she's raising that beautiful little baby with Down syndrome as her own baby. But you can see that the human body itself has become an article of commerce through this unfettered legal landscape. So what then is the anthropological meaning of this legal landscape? First of all, the first thing you notice is that persons are conceived as individuals pursuing an identity-defining plan. The goods at stake are framed in terms of individualism, privacy, choice, including sex selection, rational mastery, bargain for exchange. And what's missing is embodiment. It's especially embodiment in the relationship to procreation, vulnerability, dependence, finitude, the relationship among the generations, reciprocal indebtedness, unchosen obligations to vulnerable others, tolerance of disability or imperfection, openness to the unbidden. Children, parents, and family, even as concepts, are missing. If you think about those quotes from Robertson and Shatton, the word parent appears in one of the two quotes, but the word child or children don't appear in either one. Okay, now children and family, through the presuppositions of this landscape, again, not the people involved, but working backwards from what the landscape offers, children and family are understood through the lens of will, a project freely chosen and constructed or rejected for our own ends, and sometimes with the aid of technology. No unchosen obligations. The child is a project, the object of the parent or parent's will. It's a vessel into which parents pour their aspirations. It's a product to be accepted or rejected to the extent that it matches the parent or parent's desires. That's the anthropology that seems to be animating the legal framework in this case. Think about Shatton's phrase, the parents dream of a disease-free legacy. Now, this is really important. I've said it twice, but it's important to say it a third time. The patient, the reality of patients in this picture are in no way connected to the anthropology that the law assumes. The law assumes an atomized will seeking to assert his or her unencumbered self and constructs the legal landscape accordingly. But the reality of this situation, this human situation, is that it's populated with patients who desperately just want to be a parent. They want to be embedded in a relationship of uncalculated giving and graceful receiving with a child of their flesh. That's all they want. They feel betrayed by their bodies. They feel like, in many cases, they feel like the thing they're most meant to be a parent, is not happening because of some bodily defect or insufficiency. People don't go to the reproductive endocrinologist or the IVF doctor to assert their unencumbered will. In the same way, they don't go to the doctor more generally to assert their unencumbered will. They go because they are vulnerable. They want help. They want someone who's trained in medicine to help them to do the thing that they most want to do. In this case, it's to be a parent. And the concept of parent itself is relational. There is no such thing as a parent without a child. Okay. And so, but the law nevertheless abstracts the child from the picture and makes it just about the individual, and takes away all the guardrails and leaves patients vulnerable and subject to some unscrupulous practitioners, of course, not most, but some unscrupulous practitioners who will take advantage of them and charge them, in some cases, hundreds of thousands of dollars for IVF treatment with adjuncts. And in fact, the guardrails aren't necessary in the law just to protect us from other people. Sometimes guardrails are necessary to protect us from ourselves and from our own choices, from our own decisions that are can ultimately be harmful to the child of our hearts that we want to bring into the world. So how do we harmonize the anthropology of the law with the reality of the situation? And I think the way to start is to think about what it means to be a parent. What is the paradigm for parenthood begins with and ends with the notion that the child is a gift. Leon Cass, my old mentor, said, "A child is a gift. A child is a mysterious stranger that one welcomes and loves unconditionally." That should be the goal of everything that we do, every step of the process in the context of fertility treatment and assisted reproductive technologies. And we need to, when we're analyzing whether or not we're doing the right thing, we should ask the question, what forms of procreation align with the notion of a child as a gift to whom we stand in equal relationship, right? A child that is begotten and not made, okay? What forms of procreation align with the notion of a child as a gift versus what forms of reproduction reflect the imposition of rational mastery, control, and technology to produce a desired outcome? And we can analyze those two outcomes and say, which of the two pathways does the law lead us down? Because the law is making assumptions about who we are and what we need. It's the paradigm of gift versus the paradigm of project. And the paradigm of parenthood is a paradigm that involves procreation, not baby making. It's equal dignity, not exploitation. It's healing, not enhancement. It's embodiment, not mere will. It's humility, not hubris, solidarity, not radical individualism, family, not a mere partnership in a project. It's love and openness, not force and control. And this is the baseline, it seems to me, that we can analyze whether or not we're making the right, whether we're allowing the law, or whether we're shaping the law, or whether we're passively standing back and allowing the law to simply be a wide open space where the vicissitudes of vulnerability and unscrupulosity of certain kinds of practitioners dominate the landscape, as opposed to constructing the legal landscape with the ultimate endpoint of helping people to be parents, and to be a parent is to understand that a child is a gift, and that should be our metric for success in analyzing the legal landscape connected to assisted reproduction. So thank you very much for your attention. I'm happy and excited to have our conversation now.
Thanks, Carter. Yeah, so please utilize the Q&A function and please send your questions in and we'll get started with the Q&A. And while you're putting in questions, there was a question from Professor Dorflinger about the reference that was quoted by Dr. Bufiel at the beginning of the presentation. And yes, Dr. Dorflinger, we have that PDF and we will send that out when we send out the video. And we also will put it on the Bur Oak website where there are some other reading materials as well. So yes, please put any questions in the Q&A and we'll be happy to answer them. As people are typing questions, Carter, you know, something I really admire about your work and people like Professor Kamosi is oftentimes they very explicitly, you know, will engage sort of the other viewpoint and they'll make clear sort of the argument sort of against your point that you're making. And you've done that a little bit here, but Are there other sort of maybe counter arguments that you say oftentimes come up to when you proclaim your ideas, that we may want to think about, that thoughtful ones that you've encountered in some of the public talks that you've given that you'd like to share with us?
Yeah, no, I mean, I think the main objection, again, John Robertson is a kind of is a sort of extreme example, but he was the chair of the ethics committee of the most important professional society for assisted reproductive technologies in the country, right? So his view was representative of the most powerful lobbying professional society that there is. So I think it is fair to take John Robertson as a proxy for the arguments in this space. But in terms of, I mean, mostly what you end up getting is something like an argument about reproductive freedom and privacy. People say, listen, I should be free to try to do whatever is necessary, that I deem necessary to pursue my reproductive projects, and you have no business at all telling me what I can and can't do. Now, I understand that point, and one should, with great trepidation, propose to interfere with people's intimate decision making on matters that are of such deep importance to them. But the thing that's interesting about this area, as compared to the context of abortion, where people are arguing about, I have the freedom to reject the parental relationship by whatever means, and then they argue that there's a constitutional basis for that. I think that's not a fair reading of the Constitution or the precedents of the court that prior to Roe v. Wade. But I mean, for reasons that I explained last time. But the strange thing about this is that you really the goal of this project is to create another human being, to create a baby, right? And it's hard to find someone who will argue. And if you look at the CDC's website, right? If you look at the CDC's website, they have a great deal of information about significant birth defects. So I can just read it to you. Okay, this is on page 198, 199 of the book. It talks about the preterm birth and low birth weight associated with adverse health outcomes. Children who are born prematurely are at greater risk of death in the first year of life, as well as other poor health outcomes, including visual and hearing problems, intellectual learning disabilities, behavioral and emotional problems throughout life. There's a doubling of birth defects, according to CDC, from children who are conceived through these interventions. They say that they're 40% more likely to have non-chromosomal birth defects compared with other singleton births. They have concerns about autism. They have concerns. Now, what you'll hear is, and it's impossible to disentangle, and it's not my role to disentangle. This is like, well, the causes of those problems are related to the underlying causes of the infertility itself, not the interventions, not the techniques. And so, that's a kind of empirical dispute that you see grow up into this context. But in some ways, you might say, okay, well, in a certain sense, I understand the origin of the problem, but in some ways, it's the same outcome, right? Like it's the same result of a child who has some kind of defect or difficulty as a result of this overall project. And John Robertson said, and there are not many people who will defend the proposition that the safety of the child doesn't matter, the safety of the mother doesn't matter. That's something people can find common ground on, but we simply don't have any idea, really. I mean, we have whatever, since 1978, since Louise Brown was born, a kind of natural experiment of the many children who are all blessings, who were born through these fertility interventions. But we still don't have a longitudinal study about health and safety for mothers and babies. And that's a very basic thing, right? Safety is an ethical dimension that everybody can kind of agree upon, despite disputes about embryonic moral status or what have you. And yet we don't act like the law is not constructed at all in a way to take account of that. And it's a rare philosopher who will argue that it doesn't matter that a mechanism let me put it a different way. It's a rare layperson, parents or even practitioner who would say, yeah, the use of a technique that runs the risks of this enhanced bad outcomes is not relevant to my analysis about whether or not I should pursue that outcome or not, right? you have philosophers like John Robertson and others who say, well, if the child is born from a technique, if the child is only here because of a technique that also injured the child in the process of the child's conception and birth, the child has no standing to object to that intervention, because without that intervention, the child wouldn't exist, right? It's a kind of harm principle that applies to it's almost like a philosophical kind of paradox, right? Well, the good news is for American law and public policy, we don't have to get hung up on those kinds of philosophical conundra. All we have to say is, if we think as a society that the producing children who are disabled or have a higher rate of disabilities, if that's what was happening, I'm not suggesting that's the general thing, that would be something we could intervene and enact some kind of regulatory framework to respond to that risk. But the bottom line is, people don't, let me back up to your basic, what kinds of arguments do people make in favor of the current legal regime? It's pretty rare to find someone, when you explain to a person that there's basically no limits. No, I mean, if you look, especially if you look at England, you look at Canada, you look at other countries where they put limits on the number of embryos you can transfer per cycle. They have an entire regulatory apparatus. I think it's an imperfect regulatory apparatus, but they have a regulatory apparatus to at least ask the questions and gather information that is useful to the normative deliberation on these things. We're in a kind of black box. We don't really know what we're doing or what the consequences are. So I hope I answered your question with that sort of long-winded, meandering response. But I think that mostly what you hear is statements about reproductive freedom and privacy, but those don't go to the question of the well-being of children to be and mothers, right? Which are the fundamental safety concerns when we're talking. And then you talk about the well-being of gestational surrogates, the well-being of egg donors. I mean, there's all kinds of stuff that you can get into, and not to mention the fact that we use pre-implantation genetic diagnosis, not just for sex selection, not just for trait selection, but also to identify potential cord blood donors to pre-existing children, right? That's another ethical question that we should grapple with. It's a whole array of very complex questions that arise from our human technological capacity to fracture all the parts of human procreation into its constituent pieces. From the gathering of gametes, to the combination of gametes, to gestational development, to child rearing. Like, you could imagine 5 or 6 different people all being plausibly understood as parents in this context.
Thanks. Yeah, we have actually some questions that are following a couple themes around that I'm going to try to group together. So we actually have a couple learners that have asked similar questions. I'm just going to give them to both of them to you at the same time. So the first question is, how do you engage with arguments about pre-implantation diagnostics being for the good of the child by not bringing children into the world with disabilities? And a very similar question, Ian says, as precision medicine becomes more advanced each year, how does the concept of the begotten child interact with our ability to do pre-implantation screening for things such as cancer genetic syndromes and other health problems? And does the ethical paradigm change if we can, quote unquote, fix these problems prior to implantation rather than choose not to implant that embryo?
Yeah, so these are all questions about pre-implantation screening of different kinds. So the first thing I will say is those are all interesting ethical questions. The law doesn't distinguish between any of them. The law allows all of them, and the law has nothing to say about any of them. The law, as it's currently configured, does not have anything to say about sex. So put aside the medical applications that we were just talking about. It doesn't say anything about sex selection, doesn't say anything about trait selection, doesn't say anything about save your siblings, doesn't say about any of it, right? It doesn't even say, there's a kind of appropriations rider that seems to forbid germline gene modification in assisted reproduction. Maybe it does, it probably does. But then there are questions about, what about ooplasm transfer? What about ovarian nuclear transfer? There's so many different kinds of permutations. I would say that we would do well for the law to say something about this, right? To have some kind of overarching framework or guidelines to think through what is being done. And you could think of, and it's a little bit complex because you would be regulating in the name of a child to be, right? And I'm not using that word to refer to an embryo. I'm talking about the child that you are trying to produce, through all these processes. And one of the recommendations of the President's Council was that medicine would be improved if every single decision in the process were made with the good of that child in mind. Of course, the good of the mother, obviously, but also the good of the child in mind to try to go forward. Now, vis-a-vis the question of what about, now the questions that your learners asked bring us back in some ways to what where Joe started out, right? You can't answer those questions without having an operative idea or theory about what and who an embryo outside the body is. And I think that, and it seems to me that, I think Joe's argument was very persuasive. I think that the fact that there is what you're looking at is a human being at the earliest stage of development, albeit one outside of the usual environment in which those that human beings at that stage of development find themselves. You've conceived that human being outside the body. And it is no way, and we could go through all the different arguments for embryonic moral status. I don't think the fact that the embryo needs a hospitable environment means that it's not a human being, because we all need hospitable environments. It is a self-directing, genetically distinct whole human organism that's moving him or herself. And I say him or herself specifically because it has sex, which is why we screen for sex selection, right? And it's horrible to say it, but I imagine in practice what we're doing is we're discriminating against female embryonic human beings in most of these instances, which is unjust and I think shameful. But in any event, so if the way to think about this is, what do I owe to a human being that I have summoned into existence that's outside the body? And can I screen and then the first question was about disabilities. I don't think that you address the circumstances of disabilities by eliminating the person with the disabilities, right? So I don't think that I think that, and I don't think that it's fair to say, and I wouldn't want a framework, a policy, or even an ethical framework. I wouldn't endorse anything that would suggest that my judgment about the quality of life of that being empowers me to cut that life short in the name of relieving, precluding a life that I deem unworthy of living. I think that's a problematic and dangerous perspective, and that's a very long conversation. We can talk about it if you want to. The question of, so what we're doing when we do pre-implantation genetic diagnosis as currently practiced is to identify those embryonic human beings that meet whatever standard we've established, and those that don't are discarded and destroyed. Those lives end, right? And those lives that meet our standard, the external standard, are perhaps transferred to the womb, perhaps frozen for later future cycles. I think that that's a problematic way. That doesn't to proceed, because what you're doing is you're, again, eliminating disfavored traits by eliminating human beings who have those disfavored traits. Now, it's a very interesting question about what about when you can identify some kind of genetic abnormality or chromosomal abnormality and fix it before you transfer the embryo to the woman's uterus. Assume it's a woman's uterus, right? People are working on ectogenic chambers to gestate embryos outside the body. They're talking about immunosuppressed animals, usually pigs, to try to gestate human beings. They're talking about that. I'm not saying people are doing that, but these are the boundary crossing practices that emerge once you create a human being outside the body, and you can hold a human being outside the body, and that being can either become an object of study, it can be an object of commerce, there's a lot of dangers associated with that kind of rational mastery and control over the human organism. And I suppose I'd analyze the question differently depending on circumstances. You'd say, if I come into the scene with an embryo that has a defect, and we can fix it and then transfer the embryo and have a child that's born in a healthy way, and then isolating the question and with those premises, I think that would be something that we would want to do. There's a big debate about what do you do with embryos that are outside the body, embryos in freezers. What's the best way to respond to the human dignity of those embryos? Is it to transfer them to a woman's uterus? Is it to allow them to be adopted? Is it simply to let them thaw out and die with honor or something like that? There's a lot of debate around these things. And as my answer suggests, all of these questions all of these ethical questions arise precisely because we did something in 1968 or 69. Steptoe and Edwards were able to, isolate the human embryo outside the body and then bring that embryo, not that embryo, but bring in a similarly created embryo to term in Louise Brown in 1978. I mean, that's why we're here right now. We have all these questions and difficulties because we took what was an integrated, unified process and fractured it into its constituent parts. So, the most difficult question, and I don't want to anticipate a question and answer because I want your audience to answer a question. The most difficult question that comes up is if you can practice IVF and ART and all these other things without destroying or harming any embryos, what's the problem? That's the hardest question that I think comes up in certain circles, and those circles in which people would grant the premise that Joe began with, namely that the embryo is a living member of the human species and entitled to moral respect and the basic protection of law. What's wrong with IVF if you don't destroy any embryos? And I won't ask myself a question. I just want to flag that for your audience. And if people want to ask it, then I'll answer it. But I'm not going to answer my questions. I want to answer their questions.
There's a lot of encouragement in the chat for you to wear a Notre Dame sweatshirt next time. And if you do that, I will have to wear my Michigan face.
That's fine. Yeah, do it.
So we can do that at the end. So there's actually a question.
We'll do a fifth one. I'll wear my Alabama sweatshirt.
Oh my goodness. Oh my goodness. I'm like passing out. Ann Snow, sort of just to follow up on this, on your comment about like, what's the problem? So Ann says, what about 100 years down the road, right? When the risks are so greatly reduced and sort of like no one's harmed in the process, right? What reason would there be for anyone to sort of have children without using ART? Is there any room for any?
Yeah.
If you think about that sort of that road, is there any? So that's sort of your question that you just asked. But again,
it's not a great movie, but it's a provocative. The movie Gattaca. Have you guys seen it? You've seen the movie Gattaca? I mean, it's not a great movie, but it is. There's an arresting scene in it where the parents are in the reproductive endocrinology lab and they've got the embryos up on screen and they're choosing the traits that they want and the parents were like, we were thinking about maybe just like rolling the dice and letting nature, like, don't do that. That's irresponsible. Like if you have a child who has a, this aneuploidy or some kind of genetic defect that you didn't fix or you didn't screen for, then you've actually done something wrong to your child by bringing them into the world in this way. So I think let's talk about the kind of the normative dimension of it instead of talking about the legal dimension, because it gets too complicated in some ways to talk about the law part. Without a lot more discussion, which is probably not of interest to your listeners. Gil Meilander, to me, has the most interesting reflection on assisted reproduction and its human meaning. And again, he doesn't say that IVF should be banned or people. He just wants people to think about what it means to bring a child into the world, and whether it matters how children come to be. And there's a kind of, the emergence of a human life that supervenes on the loving act of a husband and a wife and the conjugal union is a kind of process of emergence that is suitable for a being that stands in equal relationship to his or her biological progenitors. Because what happens is the child kind of emerges from that unitive process and becomes a kind of physical manifestation and outcome of a unitive expression of love between. Now, this is the optimal idealized scenario, right? We all know that life is messy and things happen and people come into the world in different ways. And to say that, by the way, that there's an optimal way to conceive and bear a child is not to say that children conceived and born by other means have lesser value, by the way, just to be that doesn't follow at all from that proposition. I remember Richard Derflinger, who is, I think, still listening, said one time, he was asked one time, what do we do if a cloned baby is born? I think he said, and he'll correct me if I'm right, he said, well, we'll baptize it and everything will be fine, right? So like, it's no big deal. Like a baby comes in the world, it's a baby. It has all the dignity and rights and entitlements and moral standing of a baby. It doesn't matter how the baby comes into the world. But what we do has an effect on how we think about the thing. And there's a kind of paradigm of doing versus paradigm of making. I mean, the idea that, and again, I'm paraphrasing Gil, whether or not we think of what we're doing when we're conceiving and procreating is participating in a process that is not fundamentally about rational mastery, technical control, et cetera, but instead a kind of supervention and emergence in a unitive process, then we come to see that, and the child who emerges in that process, emerges from that union, really could be viewed as a mysterious stranger to be welcomed and loved unconditionally, to be viewed as a gift. And I alluded to this in my remarks. I mean, it seems to me, and I'm being normative, people can disagree with me, but we're on the right track when we're doing things that help us. We're acting on the premise and based on the proposition that a child is meant to be a gift, to be welcomed and loved unconditionally. The more we depart from that, the more we introduce rational mastery, technical control, quality assurance, commerce, all these other kinds of things enter into the picture, as we see has happened as a result of the unfettered legal landscape in the United States, and because of the understandable desires of vulnerable people, and maybe distortions in thinking about, my child isn't a product that I've ordered up, and if it has a defect that I don't want, then I want it destroyed and I want to get another one. Like how we act affects how we think, and we should embrace the proposition, it seems to me, that bringing a child into the world is participating in a process from which another human being equal in dignity to us emerges. And Gil asks the question, can you really, well, I'll put it a different way, put it more gently, is there a risk of thinking about another being that you create through a process of rational mastery as somehow not equal to you, right? Something that you made rather than something that was begotten through a process in which you participated. And it seems to me there's a wisdom, and this is in some ways the wisdom of the Catholic Church's position on the question of assisted reproduction. Of course, it relates to the moral standing of embryos, but it doesn't stop there. The Church, as I understand it, looking Donum Vitae and Dignitas Personae, would not say that if you can do IVF and no embryos are destroyed, then that's just fine. The Church teaches that you want to hold together the unitive and procreative dimensions of this process, precisely because it matters how babies come into the world. It matters. And that, which again, please, I'm not saying that people who do IVF think of their babies as products and they don't love their children the way people who produce without assisted reproduction do. Nothing of the sort. But Gil's point is we cannot escape the reality that if the way we act and the way we move in the world and think of ourselves as makers rather than doers, and it really does have an impact on, or can have an impact on, how we understand the world around us, how we understand the meaning of what we do.
Thanks. And we pushed you out of your legal sort of silo for a second into a poetic.
No, it's all right.
That was super fun. Thank you. So there's a couple questions around a same theme, which I think is important for us to think about supporting parents. I'm just going to combine the Sorosi's question and Gregory's question.
Mm-hmm.
So how do we care for or create law that will embrace those parents who are hurting, desperate to join in this mysterious relation of parenthood, without leading to and giving into the excesses of will and individualism enshrined in expressive individualism? That is, how can we have hospitality and misericordia for these parents that leads to a conception of giftedness? And just to combine that with the Sorosi's question, if you are advocating against pursuing ART and exerting the will to artificially create a child, how can we support couples facing infertility? How can we form authentic networks of interdependence to welcome such couples and provide them meaningful alternatives to ART, including but not limited to adoption?
Yeah, so the question, so there's a technical element to this question, that is, how to regulate the process of medicine is a complicated question, just as a pure legal puzzle. Like, how do I regulate the practice of medicine when the tradition of practice of medicine, as I said, is regulated at the front end of we don't have a tradition or of regulating medicine in any kind of ongoing, there's no administrative agency, for example, that regulates medicine, right? The way we regulate products, biological products, foods, drugs, etc. We don't have anything like that. As I said, for good reason. I think we have to sort of go back to square one and ask ourselves, what is there something different? And this actually comes up in abortion too, to tell you the truth, because advocates for abortion will strenuously argue abortion is just a medical procedure like any other, and for you to single it out for regulation is unfair and unjust and prejudicial. And you don't regulate colonoscopies the way you're trying to regulate abortions when colonoscopies can be dangerous too. And, these are kinds of questions that come up. But there is a fundamental difference between abortion and another health, an intervention meant to promote human health, right? Abortion is the intentional killing of an innocent human being in the womb. Okay, that's a provocative thing to say, but I think I said it that way on purpose because that distinguishes what we're doing from the practice of medicine. And I'm not suggesting that reproductive endocrinology is not the practice of medicine, but we need to think carefully about what it is that we're doing. And we have to ask ourselves, are we healing? Are you, not me, you, are you all engaged in the restoration of health? Are you engaged in the treatment of pathologies? Or are you engaged in a kind of workaround of the pathology to produce an outcome that is desired by the patient, right? A person who uses, who's a man who has male factor infertility, and you use ICSI, intracytoplasmic sperm injection, to take one of his sperm and you inject it into an egg. And let's say it's because there's a Y chromosome deletion that has male factor infertility. If there's a baby that is born from that union and the baby's a male, that baby is also going to have a Y chromosome deletion, is going to require ICSI as well, right? If I understand, somebody will correct me if I'm getting that wrong, but that's my recollection from our discussions with the scientific community when we were producing our report. Have you cured the male factor infertility by ICSI? Is that what you've done? Or have you simply circumvented the process? I think we have to get back to first principles, ask what the practice of medicine actually entails. Is it oriented around health itself? Is it oriented around subjective desires? These are very hard questions, but they're essential questions to figure out how to regulate medicine. Because if medicine is simply service providing, right? Somebody comes in, they want something, you give it to them, then we're going to regulate it like anything else with consumer protection, right? We're not going to bracketing the question of the embryo. But if reproductive medicine is different in the sense that it involves a child to be, and it involves embryonic human beings that may very well grow into the child to be that we have in mind, or maybe they won't meet the standard, whatever, maybe they won't. Is that something so different from the practice of medicine that we leave wide open, we license and certify, and then we let doctors do it? Is it so different that we actually have to step in? And in the name of what goods are we going to do that? Health and safety are things that we always agree on, right? Should we regulate these things vis-a-vis health and safety? Then the question becomes the moral status of the embryo. The question is, one of the issues that we found when we were studying this issue with the council was, we don't have longitudinal studies to give us background information on health and safety. And then secondly, the way this medicine is practiced is there are a lot of gaps in care between the reproductive endocrinologist and the obstetrician and the neonatologist and the pediatrician, where there's not a continuity of focus on the child to be. The job of the reproductive endocrinologist is to get the woman pregnant, the obstetrician is to deliver the baby, the neonatologist take care of the baby. And I'm sure I'm oversimplifying, but this, we thought, created regulatory problems and difficulties. And a lot of this is going to have to come from the professional societies themselves and the practitioners themselves to think about how they practice medicine and what goods they're going to aim at, which harms they're going to seek to avoid. But ultimately, the question is, I think we have to ask, what are we doing in the context of ART? Is it different? And does it require a different kind of ethical framework? And does it require a different kind of regulatory response? And how to do that, it's very, very hard to think. And notwithstanding the fact that, we have an issue of federalism. I mean, medicine is regulated at the state level. Different states regulate medicine in different ways, different practice groups. And different specialties have different standards and so on for board certification. It's a very, very hard question. We'd have to remake the way we think about regulating medicine to do this. But in the meantime, I would just encourage, and this is part of the law, by the way, is data collection, right? Surveillance and data collection. I don't mean surveillance in the sense of listening to people's phone calls. I mean in the sense of gathering real information about what is going on the ground, what is the relationship with different clinical choices and different kinds of outcomes, and whether or not, are we going to leave it to plaintiffs' lawyers to basically be the regulators of the practice of medicine? And that's what we've done for most other branches. Doesn't make sense here. I think there are complexities that make that not a good model.
Thanks. Well, friends, sadly, we've come to the end of our time together. Thanks for another fascinating discussion. Thanks, Carter, for being here and giving us a lot to think
Can,
about.
can I say one? Can I say one last thing?
Sure,
Kristen?
of
I'm sorry,
course.
and
No,
it just occurred to me. I apologize. I think we need to talk about adoption in the same context that we talk about infertility. And I don't want to make these things. It feels manipulative to make these things personal, but my wife and I suffer from unexplained infertility, and we have 3 boys that we adopted. And I can't tell you. And Gil Mylander again wrote the most beautiful book that I know of, and in the first book in the series that we edited, the DeNicola Center for Ethics and Culture at Notre Dame. It's like about forming families through adoption. I think it's something not by nature but by grace is the title of the book, and it shows you how adoption can really manifest the paradigm of parenthood in a very beautiful way. That is, there's no more mysterious stranger than the child who is not of your flesh, right? That you graft onto your family tree, and to give that child a place of belonging and to make a family. Not there, and Russell Moore says, and he's right, there are no adopted sons and daughters, there are just sons and daughters, right? Adoption is a form of, it begins in usually in a kind of tragedy where there's a child who doesn't have parents who are willing or able to take care of that child, but then it's redeemed by virtue of finding a place of belonging for that child, in which a true son or daughter emerges from that process. It very much requires being open to the unbidden and to be tolerant of imperfection, both on both of you as a parent and whatever, we're all human beings, and it seems to me that I would really encourage people who are struggling with infertility to think about how, there are many ways to form families in a real sense, and not in a merely symbolic sense. It's not simply a rescue operation, even if it might begin as a rescue. It ends with the formation of family and a place of belonging, in the same way that any family is formed. And so I would just encourage those people who are listening to my voice right now, who may be struggling with infertility and are feeling betrayed by their own bodies and feeling like they don't know what to do, to really think about adoption. And I can tell you from personal experience, it is the most beautiful thing and rewarding thing. It's the best thing you can do, period, full stop. I am, the most important thing that I am is a father to my sons, and they are not adopted sons. They are my sons, and they are mine just as if they had come from my body and my wife's body. So I'll leave you with that.
Thanks, Carter. Thank you for sharing that personal story and for making sure we touched on adoption. Yeah, Gil's book is called, just to remind people, Not by Nature, but by Grace, Forming Families Through Adoption. It was published by Notre Dame Press in 2016. Yeah, thank you so much to everybody today for your thoughtful questions and comments that we received. Our last and final session will be Monday, April 18th. And the title of that session will be End of Life and Human Flourishing. In the meantime, if there are any students or trainees that want to continue these kinds of conversations with me or any of my colleagues, please reach out to me. Or if you're interested in hearing more about or supporting our work at the University of Michigan Medical School Program on Health, Spirituality, and Religion, or the Bur Oak Foundation, please see me. Good night, friends. Thanks, Carter. Thanks, Joe. Thanks to y'all.
Thanks, everybody.
Good night. Bye-bye.